Hi there, this is Jonathan Ginsberg. I'd like to answer a question I get from my clients sometimes, and that is, how much is this going to cost me? I want to hire a lawyer. I think I need to get a lawyer to represent me at my Social Security disability hearing, but I don't have thousands of dollars to pay a lawyer. Well, that's okay, because most disability lawyers, myself included, we take cases on a contingency fee contract, and that means there's no fee unless you win. The fee is going to typically be 25% of past due benefits. What that means is if you're applying for benefits, let's say you're applying in 2008, you go to a hearing in 2011, you're approved, and there's 2.5 years of past due benefits. Your benefit amount is, let's say, $1,000 a month, and there's $30,000 there. My fee is going to be 25% of that with a cap. Currently the cap is $6,000, which makes my effective fee a little bit less than 25%. But basically that's how I get paid. I get paid only if I win, and my fee is going to be 25% with a cap of, again, currently $6,000. It allows you to hire an attorney, an experienced attorney, without having to come out of pocket for any money. The only out of pocket you might have would be sometimes there's medical reports we need to get, and those have to be paid for by the claimant, by you. Again, that can be paid at the end of the case. But for the most part, you don't have to come out of pocket for any money at all. It can be done, as I said, on a contingency basis. Ongoing future benefits, in other words, if you're approved and you start getting benefits going forward, that goes 100% to you. So there's no percentage on that. It's only on the past due lump sum benefit, only, again, if we win. And it's really a pretty equitable way for you to get an experienced attorney, and again, allows me, I pretty much choose pretty good cases. So normally if I'm taking a case on a contingency, that means that I think it's a pretty good case. There is an alternative way for an attorney to get paid that's called a fee petition. I don't do them very frequently. That's when I have to keep my time and I break down exactly what I did. That usually is in a situation where there's a workers' compensation offset, or there's some other reason why I cannot get paid on a contingency based on past due benefits. But again, that's something we decide at the beginning of the case, and I'd say well over 95% of the cases I take are done on a no fee unless you win situation, and the no fee unless you win is based on past due benefits only. So that's how I get paid in most cases. Most attorneys do it the same way. The fee contract, by the way, has to be approved by the Social Security judge. So we use a standard contract that's been approved, for years and years. But again, you have a right to look at it. You have a right to challenge the fee if you feel it was not fair. But again, as long as it fits within that 25% on past due benefits with a cap that's set up by the commissioner, the $6,000 or whatever the cap is at the time you file. That's a pretty good way to do it without having to come out of pocket. So the short answer, I just gave you a long answer. The short answer is that in most cases you do not have to come out of pocket to hire an experienced Social Security disability lawyer who will zealously represent you, appear with you at your hearing, and make a compelling argument that you are entitled to disability benefits. So this is Jonathan Ginsberg. Hope this has been helpful, and we'll talk to you soon.